हाई कोर्ट की प्रैक्टिस नहीं है आप कि तहसील में खड़े नहीं है आप।
employee of working as a billing clerk मतलब in the unit run canteen of the armed forces मतलब
36,030 रुपए किस चीज की रिकवरी है? मेरी बात का उत्तर दे दीजिए। जिसका मैडम ने पत्र लगाया के सिंह ने अभद्रता करी। नाउ आई विल ग्रांट यू टाइम, यू कैन विथड्रॉ दिस पिटीशन और टुडे आई विल डिसाइड इट ऑन मेरिट्स। ऑर्डर डेटेड टू
Sri Naveen Vivek. Yes, जी.
in this case मतलब in pursuance to direction of my lordship मतलब on the last date of hearing मतलब that the pay slip of the petitioner be brought on record मतलब I have filed a मतलब application मतलब that is an IA number 3224/2023 मतलब this is a case 2024 मतलब is a covering memo मतलब
कवरिंग में हो ये
मतलब this is a case of recovery from class 4 employee the petitioner herein is an employee of working as a billing clerk in the unit run canteen of the armed forces and this is a second round of litigation on
आर्म फोर्सेस का यहाँ चलेगा कि आर्म फोर्स पैनल में
they are not a government employee
they are not the employee of the Union of India they are not the employee of armed force, they are the employee of the canteen, that is the
कॉन्ट्रैक्टर के एम्प्लॉई
totally private venture.
बताइए क्या है?
in this case this is a
made recovery
as per the document I have filed with covering memo
Order number 3 is passed the order it is the head of the canteen,
अच्छा
but it is a private venture.
page 3 of the covering memo wherein under the heading of deduction they have deducted around 2,710 rupees a very meager amount of rupees 8,129 rupees is paid to the petitioner
बाकी तो आपके जो है
further I filed some documents that is an IA number 4
रिडक्शन है ये तो बता दीजिए।
may kindly see the document which I have filed along with my additional documents this is an IA number
₹36,030 किस चीज की रिकवरी है?
the ground for recovery is that that I have been appointed on ad hoc basis and subsequently after completion of 6 months no order has been passed for permanent employment of the petitioner it is mentioned at page 31
31 of the
petition
पढ़िए 31 में क्या लिखा?
page 31 this is a recommendation of board of officers who clause 3 Shri Mrs. Sudha Arode was appointed as billing clerk on ad hoc basis for a period of 6 months only with effect from 7 April 2008 while letter dated so and so dated 7 April 2008 there has not been any authority confirming her permanent employment in URC post completion of 6 months of her employment in URC may be reviewed or regularized based on suitability report. Thereafter, another BVO was conducted, that is an exact P5, wherein at page 42, firstly, page 41.
41 here.
This is a finding recorded by the Board of Officers, clause 6, Mrs. Sudha Arore past so and so was appointed as billing clerk with effect from 7 April 2008 on ad hoc basis for a period of 6 months. Only wide so and so dated so and so she has completed 12 years service approx. As per OMG branch letter dated so and so dated so and so during refixation of pay she has been placed in a basic pay of 9,422. As per recommendation of refixation of BVO assembled wide SRO so and so dated so and so she is placed in basic pay of rupees 10,429 with effect from August 2020. Suitability report is placed as annexure. Now may turn to page 42. This is a recommendation wherein it clause E Mrs. Sudha Harode was appointed as billing clerk with effect from 7 April 2008 on ad hoc basis for a period of 6 months.
When was this letter issued?
It was issued on 2021.
अब ये रिकवरी किस पीरियड की है?
And the recovery
where is the letter?
this is a recovery of month of February 2023.
नहीं एक सेकंड थोड़ा सा ये बताइएगा। में लिखा है she continued to work at Patna. An appointment letter as billing clerk may be issued. When was appointment letter was issued in your favor?
The appointment was issued
give me the date.
The appointment letter is an exact P2
Page number.
7th April 2008, page 24.
ये नहीं है अपॉइंटमेंट ऑर्डर में, ये जो आपसे कहा जा रहा है,
हाँ।
ये जो इसमें लिखा है रिकमेंडेशंस में जो लिखा है,
हाँ।
ये अपॉइंटमेंट लेटर कब का है, ये कहाँ कब इशू हुआ है?
But as
ये
no
अगला तो
such,
यहीं से शुरू होता है।
but no
20
such,
जुलाई 2021 को रिकमेंड किया गया,
but no such appointment letter has
हाँ,
been
तो
issued.
फिर
But
यहीं से तो झगड़ा शुरू होता है।
thereafter I challenge the recovery before this honorable court, my lord. This honorable court, my lord, had stayed the recovery, my lord, and directed the respondent to decide my representation, my lord. That has been rejected by annexure P1, my lord. Wherein at page 23, my lord, they have said
इस तरीके से समझ में नहीं आएगा, एक एक करके बताइए। ये रिकवरी किस ग्राउंड पर है कि आपका इरोनियस पे फिक्सेशन कर दिया, उसकी रिकवरी है ये?
that I have not been permanently classified after appointment my ad hoc basis.
तो वही तो आपसे पूछ रहे थे, रिकमेंडेशन से पेज 42 की रिकमेंडेशन से आपको क्या फायदा मिलेगा? अनलेस एन ऑर्डर इज इशूड इन योर फेवर परमानेंटली क्लासिफाइंग यू, बताइए मुझे।
But it is their mistake, my lord. They have not issued the
Not their
appointment.
mistake. You should seek that relief. Have you sought this relief?
Hello?
Have you challenged their action of not permanently classifying you? What is your status? You are an employee of a canteen.
My lord.
ठीक है,
My lord.
CGIT जाके अपना परमानेंट क्लासिफिकेशन का ऑर्डर लीजिए अगर ये नहीं कर रहे तो।
My lord, in this petition, I am not seeking the claim for
That's what I'm
permanent
saying. So your
classification.
this recovery is
My lord.
on account of grant of erroneously higher pay, treating you to be a permanently classified employee, whereas you were not permanently classified. Now, unless you have shown this page 42, annexure P5, unless appointment order, regular appointment order is issued in your favor, how you are entitled to get that salary? इतना तो केस है।
As per at page
As per नहीं, आप मेरी बात का उत्तर दे दीजिए। रेगुलर एम्प्लॉइज को जो पैसा मिला था वो आपको गलती से दे दिया गया, वो पैसा आप पाने के पात्र नहीं थे क्योंकि आपके पक्ष में कोई परमानेंट क्लासिफिकेशन का ऑर्डर नहीं है।
They are agreeing that I have been permanently classified, but no such order has been supplied to us.
Unless the order comes, you cannot get any relief.
But my lord,
and your remedy is before the CGIT.
My lord, for my lord,
CGIT जाएंगे ना यादव साहब? ये
CGIT में
they are my lord contractual employees.
उसमें वो नहीं है, उसमें
they are contractual.
शेड्यूल में नहीं है शायद
ये कैंटीन,
तो
ये कैंटीन के एम्प्लॉई है ना, कैंटीन तो शेड्यूल में आएगा ना, आर्म्ड फोर्सेस शेड्यूल में नहीं होंगी। आर्म्ड फोर्सेस अगर अपना कैंटीन ठेकेदार के माध्यम से चला रहे हैं, जिसका मैडम ने पत्र लगाया के सिंह ने अभद्रता करी, तो भले ठीक है आपका सुपरविजन होगा उस कैंटीन के ऊपर, जब आप आउटसोर्स कर दिया, आपने ठेकेदार को दे दिया, दे आर बेसिकली एम्प्लॉइज ऑफ अ ठेकेदार।
कैंटीन और इनके जो सैलरी भी है वो उसके प्रॉफिट से इनको मिलती है।
हाँ, तो वो परमानेंट क्लासिफिकेशन वो वहां जाके सीख कर रहे हैं अप्रोप्रिएट अथॉरिटी के सामने। यही डिस्प्यूट है ना, ये परमानेंट क्लासिफाइड मान के इनको जो सैलरी दे दी गई उसके लिए पात्र नहीं।
Now, my lord, they have fixed the, my lord, installments, my lord. I have filed the document with my additional document, my lord, wherein, my lord, they have fixed the at page 5, my lord, that is an IA number 4036 public 2020.
क्या है
Page 5, my lord. This is a due drawn statement of petitioner, my lord. Wherein at note, my lord, they have mentioned that total recovery amount will be recovered in 35 installments, out of which rupees 2710 in 34 months and rupees 1686 in 14 installments.
ठीक है, CPC भी ये कहता है कि 1/3 से ज्यादा रिकवरी नहीं होगी, ये तो 1/3 से भी कम कर रहे हैं।
But my lord, this recovery is, my lord, contrary to law, my lord, because I am a class 4 employee, my lord. There is no misrepresentation or fraud on my part.
You are an employee of a private contractor. This law laid down by Supreme Court in Rafiq Masih is not.
There is no contractual contractor, my lord, is involved. I have been directly appointed by the unit run canteen, my lord, on contract basis.
Unit run canteen इनका contention है ना, it's run by a private contractor under the supervision of the armed force officers.
या वो ऑफिसर्स ही उसको डील करते हैं।
पर इसमें मगर ऐसा कुछ मेंशन नहीं है, while my lord rejecting.
मैं आपसे निवेदन तो कर रहा हूँ, प्रमाणित करिए ना कि आप you are an employee of the armed forces. Then you will go to the armed force tribunal.
My respectful submission is this, my lord. Herein in this petition, I am only challenging, my lord, the recovery order.
At my command, your respectful submission is bereft of legality. It has to be legal submission. Only respectful submission will not help you.
It is not their case, my lord, that my appointment is illegal, my lord.
Shri,
My lord, in other matter also, my lords have issued the notices, my lord, to them.
notices, ऐसा नहीं, right, it is not your right. आपसे जब दस्तावेज मांगेगा उनको देख लिया कि लिखिएगा श्री प्रतीक दुबे, learned counsel for the.
My lord, I may be permitted, my lord, I'll seek instruction whether there is any order exists, my lord, but
Now I'll grant you time. You can withdraw this petition, or today I'll decide it on merits. ये हाई कोर्ट की प्रैक्टिस नहीं है आप, कि तहसील में खड़े नहीं है आप, कि जो है आपने जब पूरी बहस हो गई उसके बाद आपने कहा I may be permitted to you seek instructions.
I am only, my lord,
No,
come
I'll
before
not
this
grant
court,
you.
my
I'll
lord,
not
challenging the recovery, my lord.
I'll not grant you any
I'm
time.
not seeking classification.
I have understood that.
My lord.
I understood that. Either you withdraw it, seek permanent classification first, and then
But my lord, at least
consequential benefit.
because I am still in employment, my lord, or they are, my lord, one to on
You are
earlier.
in employment, therefore recovery can be made.
On last date, my lords have directed, my lord, to show the whether they are deducting an amount or not, my lord.
दिखा दिया वो, चलिए देखिएगा. Shri Pratik Dubey, learned counsel for the petitioner. Shri Upendra Yadav, learned assistant solicitor general for the Union of India. Next, petitioner has filed this petition challenging order dated 2/1/23, whereby certain recovery is initiated against the petitioner on account of erroneous release of pay. Full stop. Petitioner's contention is that petitioner is working in the canteen, group run canteen, and
Unit
since 2006. 6 है ना ये, page 42 पे. Since 7 April 2008 as billing clerk, and therefore she is entitled to get the pay scale of a permanently classified employee. Full stop. It is submitted that recommendations have been made in this behalf by the concerned committee as is available with Annexure P5. Full stop. It is thus submitted that the recovery be set aside and impugned order be quashed. Next paragraph. Shri Pushpendra Yadav, learned counsel for the respondent, submits that petitioner is not an employee of armed forces. Stop. Certain officers in their capacity as a cooperative or in their capacity as an association run a unit canteen.
My lord, may I submit?
Unit canteens are managed
My lord, at page
privately.
41, my lord.
They are not part of the armed force structure. Full stop. Persons like petitioner are appointed by a unit run canteen and their salary oblique wages are paid out of the profits run by the said canteen. Full stop. They are not the employees of the armed forces. Full stop. Petitioner, though there is a recommendation for petitioner's permanent classification, but that order of permanent classification is yet not on record. And therefore,
My lord, may I?
erroneously when higher remuneration was paid to the petitioner, treating her to be a permanently classified employee, then that is sought to be recovered in easy installments of rupees. कितने रुपए के installment में कर रहे हैं?
सुधा 2710
2710
In 34 months and
for
1686.
34 months, and then 1686
in 40.
as a fifth installment, 35th installment. Full stop.
Or in 14 installments.
In 14 installments.
My lord, may I? My lord,
हाँ.
I may be, my lord, at page 41, my lord.
वो देख चुका हूँ मैं.
My lord, उसमें इस तरीके से mention किया है, my lord,
वकील
that
साहब इस तरीके से बहस नहीं होती है. वो
with
मैंने
effect
देख
from
लिया उसको.
11 August 2014,
not-
my lord, my services have been,
आप
my
अपने
lord.
केस दूसरी बेंच में लगवा लीजिए, मैं नहीं सुन पाऊंगा आपको. इस तरीके से नहीं होता है. आप हाई कोर्ट में खड़े. No, you showed me that page. I have already seen 41, 42. Please don't interfere when I am dictating the order. I'm sorry.
My lord, I am highly apologizing, my lord,
No.
but my lord, may kindly appreciate, my lord.
You will not. I'll not hear you now. क्या लिखा? In 14 installments per month in for 14 equitable installments. Full stop. This recovery is assailed on the ground that petitioner is a class 3 employee and therefore no recovery can be made against her. Full stop. Next para. This is second round of litigation. Earlier, petitioner had filed WP 25454/2022, which was decided by a coordinate bench on 18 November 2022, asking the respondent number 3 therein to decide petitioner's representation. Full stop. Now, while order annexure P1 dated 2nd January 2023, petitioner's representation has been decided. Petitioner's representation is decided, and it is noted that petitioner was erroneously paid higher basic pay than her entitlement, and therefore, on account of incorrect payment of higher pay scale and certain overdraws made by the petitioner, recovery has been ordered, which is justified in as much as easy installments have been fixed for the petitioner, looking to the fact that she is a class 3 employee. Next paragraph. Fact of the matter is that nobody can seek undue enrichment without showing his or her entitlement to a particular pay scale or pay. Full stop. Admittedly, petitioner is not a permanent classified employee. Full stop. There is only recommendation in her favor. Issue an appointment order. Full stop. That recommendation is yet not acted upon, in as much as when the petitioner counsel is requested to show the orders issued after the said recommendation was made on 20 July 2021 as contained in annexure P5, then petitioner is not in a position to show from record that said recommendation was acted upon. Full stop. Recommendations are not binding. Unless recommendation is acted upon, petitioner is not entitled to higher pay scale. Full stop. Therefore, merely on the basis of recommendations, since petitioner is not entitled to higher pay scale which was erroneously given to her, therefore, canteen being a non-profit organization, and having been paid higher remuneration than the entitlement, is entitled to recover the same, and since recovery is being made in easy installment 48 easy installments spread over a period of 4 years, this court is of the opinion that no indulgence is required in the matter. Petition fails and is dismissed.
My serial number 2.